The drifting boat of liquidated damages. Section 75 of the Contract Act 1950 states, when a contract has been broken, if a sum is named in the contract as the amount to be paid in the case of such breach, or if the contract contains any other stipulated by way of penalty, the party complaining of the breach is entitled, whether or not actual damages or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or, as the case may be, the penalty stipulated for. Liquidated damages and penalties. In this case, the federal court decided. Section 75 of the Contract Act 1950 makes no distinction between liquidated damages and penalties. Court to determine reasonable compensation. Where a fixed sum is specified in the contract as payable upon breach thereof, whether or not actual damage or loss has been proved, the court must determine what is the reasonable compensation. Party to prove actual damages or reasonable damages. The party who is claiming for actual damages in action for breach of contract must still prove the actual damages or reasonable compensation. According to court good sense and fair play. Where the court finds there is evidence of clear loss which is not too remote, but difficult to assess damages due to no known measure of damages, the court ought to award damages which are reasonable and fair according to court's good sense and fair play. Sum must not exceed specified amount in contract. In any event, the damages awarded must not exceed the sum named in the contractual provision. Sakinas SDN-BHD v Su Yik Hao and Anna 2002 5 MLJ 497. The court classified the principals in Selva Kumar case into two categories. The first category, where evidence show real loss and loss not too remote but difficult for court to assess damages due to no known measure employable, the court will award damages which are reasonable and fair according to court's good sense and fair play. The second category, where damages for loss is not too remote and could be assessed by settled rules. Court will not award damages if actual loss or damages cannot be proven. Cubic Electronics SDN-BHD, in liquidation, v Mars Telecommunications SDN-BHD 2018 MLJU 1935. The federal court held that Selva Kumar and the subsequent cases should not be interpreted to mean that proof of actual loss is the sole conclusive determinant of reasonable compensation. Breach of contract and contract contains damages or liquidated clause. The court held that there must be a breach of contract and the contract contains a damages or liquidated clause which stipulate a sum to be paid in case of a breach. Maximum sum. The actual loss or damages cannot exceed the sum stated in the damages or liquidated clause. Unreasonable compensation. The burden is on the defaulting party to prove the sum is unreasonable if he feels extravagant. Counterclaimed for defective works and LAD arising from the delay. LAD. The High Court ordered the appellant to pay LAD but the Court of Appeal reversed the decision. Respondent failed to prove LAD. The Court of Appeal held that the respondent failed to prove the LAD in accordance with Section 75 of the Contract Act 1950. Shift of position. It can be seen that the Court of Appeal did not follow the decision of the federal court in Cubic Electronics. Future position. How the decision of the court will go in the future case is yet to be seen. Where are we now? Section 75 of the Contract Acts 1950 states clearly that the party complaining the breach is entitled to reasonable compensation not exceeding the amount stated in the contract, whether or not actual damages or loss is proved to have been caused. Selva Kumar case. But in Selva Kumar case, the claimant party cannot recover simpliciter sum fixed in a damage clause whether penalty or liquidated damages. He is required to prove his actual damage he suffered unless the loss is not able to be ascertained. Cubic Electronic case. In Cubic Electronic case, the federal court held that there is no necessity to prove the actual damages or loss in every case so long there is a breach of contract and a clause containing a sum stated therein. The innocent party is entitled to receive a sum not exceeding the sum stated in the contract irrespective of whether the actual damages or loss is proven. If the defaulting party disputes the reasonableness of the compensation, the burden of proof falls on him or her to show that the damages clause is unreasonable or to demonstrate from available evidence and under such circumstances what comprises reasonable compensation caused by the breach of contract. Failing to discharge that burden, or in the absence of cogent evidence suggesting exorbitance or unconscionability of the agreed damages clause, the compensation stipulated in the contract ought to be upheld. Solian Yi, Goldwell Trading, case. However, in this case the Court of Appeal held that the party claiming for damages or loss must prove that he suffered actual damage or loss, which he failed to do so. Where are we heading? In view of the different decisions by the courts, with the latest decision by the Court of Appeal, it will be difficult to predict what the boat direction will be. Terms such as actual damage or loss, reasonable compensation were difficult to define or subjective. Furthermore, calculating the actual damages or loss at the time of the breach were not an easy task. Neither the simpliciter or sum fixed in the damages clause reflect the actual damages or loss suffered by the claiming party.